Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I'm excited to be moderating today's webinar on how to leave a limited content message. One of the most interesting components of the debt collection rule from the Consumer Financial Protection Bureau was the introduction of a limited content message, which, if used properly, does not count as a communication under the Fair Debt Collection Practices Act. But there are a lot of concerns about how this message is used. In this webinar, which is being sponsored by TCN, we have a panel of compliance experts who are here to break down the limited content message and share some best practices about how to use it. This is the first in a series of webinars aimed at helping the industry better understand the CFPB's debt collection rule and how to apply it to your operations. And all the webinars in this series are going to be sponsored by TCN. Before I introduce the panel, let me take a quick minute and say a few words about accountsrecovery.net. Accountsrecovery.net is a news and information platform for the credit collection industry. The site publishes unique and curated content, maintains a number of email newsletters, hosts webinars like this one, offers podcasts and videos, and a Slack channel, all for the credit collection industry. All of that content is free for anybody in the industry to use, and I hope everyone is using it every day. Let me introduce you to today's panelists. Sarah DeMoss is the Director of Compliance and Licensing at Premier Credit of North America. She also acts as in-house counsel for the organization. Besides general compliance matters like complaints, quality assurance, and auditing, Sarah also oversees training, HR, and legal for the company. She's been at Premier for more than 6 years, and prior to joining the company, she worked for the national collection law firm of Rausch Sturm and is licensed to practice law in both Indiana and Minnesota. Mike Frost is a partner at Malone Frost Martin. His practice is primarily focused on compliance, general counsel services, and litigation defense for the arm industry. He has more than 15 years of experience as an executive at a large collection agency where he was responsible for legal, compliance, government affairs, legal operations, sales, and marketing. Mike serves on the board of directors at ACA International and is a speaker on a variety of industry topics for many trade associations. Michael Clutho is a shareholder with the Minneapolis law firm of Bassford Remley and chairs the firm's Consumer Law Defense Practice Group. A significant part of Michael's practice involves the defense of collection attorneys and collection agencies facing FDCPA, FCRA, and TCPA lawsuits. Michael has defended thousands of consumer lawsuits brought against collection professionals and frequently presents on FDCPA, FCRA, and TCPA related issues, and is a certified instructor through ACA International. Britt Suttle works in the Pennsylvania office of Barron and Newberger. She is a member of the firm's Consumer Financial Services Law Practice Group. Prior to joining the firm, she was a shareholder at Burton Neal and Associates, where she served as the firm's Director of Compliance. Britt is the president of the Pennsylvania State Creditors Bar. She is a current member of the board of directors for the National Creditors Bar Association and is the immediate past parliamentarian for the association. The format for today's webinar will be a panel discussion. We encourage everybody to ask questions, and we'll get to them as our discussion is ongoing. To submit a question, please either enter it into the Q&A tab or the chat module on your Zoom webinar control panel. This event is being recorded, and a recording will be made available in the coming days on accountsrecovery.net. Since we're going to be talking a lot about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area. It should never be used to replace the advice of your own legal counsel. With that, let me bring on our panel and start our conversation today. First, let's start with the most obvious question for those who aren't aware of what it is. Let me ask, what is a limited content message? Michael Clutho, since you happen to be to my immediate left, why don't you take that question for us if you don't mind?
Sure. Limited content message is actually, I look at it as the CFPB embracing what we wanted all along, to be able to give a message that is limited in content, doesn't have any risk of disclosure to a third party, that it's about debt collection. That's kind of been the battle with FODI and Zortman, and I'm sure we'll talk about all that. But CFPB embraced that and ended up saying, if you give a message that gives the business name of the debt collector, assuming that name doesn't disclose that you're in the debt collection business, you request a consumer to reply to the message, you give the name of the person who to, one or more who they should talk with, and then you give the phone number, that's a limited content message. It's kind of like, hey, Mike Frost, this is Michael Clutho with ABC Company. Please give me a call at such and such a number. That's the extent of it. They give the example in there. It says, this is Robin Smith calling from ABC Incorporated. Please contact me or Jim Johnson at 1-800-555-1212. So a very simple, limited content message.
Excellent. Well, thank you for that. Mike, Sarah, Britt, anything else you want to add on top of our starting definition of what a limited content message is?
Yeah, I'll jump in. I just think it's important to remember that this is only for voicemail messages. So this isn't going to work if if you call and somebody picks up the phone and and it's not the consumer. You can't leave this message with them, and you can't use it for email or texting. So I think that was one thing the Bureau had initially considered, and then they backed away from. So as long as it's a voicemail, everything that Michael said applies.
That was my next question, which is in what communication formats can it be used? So thank you for answering that. So let me ask this. Obviously, the CFPB has made this available. So what are the benefits to using this message as opposed to using a traditional FODI or Zortman message, which is what most collection agencies are using today when leaving a voicemail? Mike Frost.
You're on mute, Mike.
I am. Thank you, Michael. I think this kind of goes back to the whole Zortman discussion, and Michael was the one Clutho here was the one that actually litigated that case that helped us curb the issues back in the past when we were all fighting the FODI issue. You were leaving a 52-second message that had a ton of information in it. It was probably a third-party disclosure, and we had a lot of litigation around that. So that was a great case that kind of sparked not only a change in the industry and how we left voicemail messages at that time, but probably had a very big influence and impact on how the CFPB came out with this model notice for voicemails. I think one of the big things that we've seen from Zortman was the 11th Circuit had a case called Hart versus Credit Control. And in that case, the 11th Circuit actually identified a Zortman style message as a communication. So one of the things that we had in the past prior to this with the CFPB was we had somewhat of a split, and I wouldn't say a split. We had one circuit that was actually identifying those messages left that were Zortman's as communication, where the other circuits weren't viewing it that way, or at least the other district courts weren't. So this probably clarifies that issue. I know a lot of agencies excluded, their voicemail message process in, Florida, Alabama, and Georgia. Simply because of that case that came in, Hart versus Credit Control. So that may be an area that's cleaned some things up if agencies do actually follow this process. The one thing that I know has been voiced in the community in our industry is really what about those agencies that have the term collection or identifies something about collections in their name? Can they use a DBA? Can they how do they overcome that without going through an entire name change? And DBA license, the licensing requirements for DBAs can be fairly traumatic too, because some states actually require you to do it by county. So there's it's not a perfect opportunity to be able to use a DBA. There's going to be some underlying, groundwork for that, but it's probably the best method for those agencies that do have a term collection or something in there to be able to conform and utilize this type of a process.
Excellent. I just had the brilliant idea. I'm going to launch a poll. I'm curious for those of you who are watching and listening, whether or not you're leaving a voicemail now, and if you are, whether it's the FODI style or the Zortman style, excuse me. So if you see the poll on your screen, if you just want to take a second and fill that out, and we'll share the results in a minute. I will use this time to ask a question that's come in from the audience. And remind everybody, if you have a question for our panel, type it into the Q&A or the chat module, and we'll get it asked. Is there any input or ideas from the panel on using ringless voicemail to deliver the limited content message? Would that be okay or not okay? What does everybody think about that?
Actually, the Bureau specifically says it is okay. They don't opine. I apologize, I don't have the exact page on there, but they do actually say if you leave a limited content voicemail using a ringless voicemail, that's fine. They do not opine, and they take care to say that they are not opining on whether or not ringless voicemails are okay. Somebody just put in the chat box, it looks like it's page 56. But yes, so under the Bureau's analysis, they do believe, thank you for that, Todd, and for that, yeah, use a ringless voicemail if you want, but there could be all those other concerns regarding ringless voicemails beyond just the limited content message.
Yeah, Mike, when you think about this limited content messaging, that's what it is. It's voicemail messaging. It doesn't apply to anything else. I would, ask the question of the other panelists, and Britt, I think you mentioned, so, you call and a live person answers and it's not the consumer. Isn't this kind of along the lines, without maybe giving the name of the company, but you would say, this is, Mike Frost, can you ask Britt to give me a call at such and such a number? Can we still do that? Mike's shaking his head no.
No, I think it's said in the rule that it doesn't apply to messages left with a third party. And you feel free to correct me if I'm wrong there, but that's what I recall reading through there. And I don't know if it really applies to live attended messages either. So what does that leave you with? A pre-recorded message, which creates another TCPA potential liability too. So does that really create the framework that's going to be able to help us, get some type of relief through this limited content message if there is an ability to, if you have to leave it pre-recorded, which I don't know that that's truly the case, but if you are leaving it pre-recorded, you still have the TCPA elements that you have to deal with.
Right.
Go ahead, Britt. Sorry, go ahead.
I was going to say, I think there were a few cases several years ago at this point. I apologize. I don't have the exact case name in front of me, but I think if you are going to leave a message with a third party, even if it's something as simple as, hi, this is Britt, I'm looking for Michael. Oh, you're Sarah. Okay, well, can you please tell Michael that I called? There were, a very sparse, but a smattering of cases that held that could possibly violate the FDCPA for, any number of reasons. So I always, back when I trained collectors, I would say, as much as they want to leave the message, as much as you're trying to get them to call you, thank you, I'll try again later. Just end the call. The less said, the better in those situations.
It also takes away the purpose of what they're trying to do. I mean, they specifically say you can use this against, someone coming at you with third-party disclosure, as long as you have policies and procedures and other things in place. And if you're just willy-nilly saying things to people that answer, it's not what they're trying to do. They're trying to limit this to just one voicemail, one text, one script kind of thing, and leave it at that. Otherwise, you won't be protected.
I know we're getting a little off topic. I just raised that point because there actually is in the Minnesota licensing statute for collection agencies talk about leaving messages with people at home and things like that. It seems to embrace. So I don't know. I mean, I find, Britt, I accept what you're saying. That's the most conservative route to say, I'll try again later. I'm not so sure that, we get anywhere with that. Sure would be nice, wouldn't it, to be able to say, hey, could you ask him to call, Michael Clutho, and here's my number. Wouldn't that be great?
I'm not so sure a limited content message is going to drive, a bunch of down calls either. So.
Yeah.
For those of you who are watching, I put the poll results on the screen. 40% of the people who responded are not leaving voicemails. Of those who are, 34% are using Zortman style and 26% are using the Fody style. So it's an interesting little insight into our audience today. I'm just going to hit the pause button very briefly on our conversation, which is off to a great start because I want to invite McKay Bird from TCN, the sponsor of today's webinar, to say a few words. McKay?
Hi, thank you, Mike, and as well as to all the panelists for participating and making all of this possible. And kudos to all of you for joining today, wherever you are. But just as a quick introduction, my name is McKay Bird. I'm the marketing director here at TCN, and many of you probably have heard of TCN, but we've been serving the collections and ARM industry for over 20 years. TCN provides cloud solutions that are cost effective as well as cutting edge for the industry. We provide services to thousands of businesses worldwide through our award-winning call center platform. Something that is unique to TCN is we've been continually involved with the TCPA and as well as with the CFPB and as well as a lot of the changes that are ongoing. And we've developed specific tools that help with some of the current regulations. And one of those tools that we've developed is called natural language compliance, and it uses smart algorithms to build rules naturally. You simply type in a rule and TCN's algorithm will help put that rule into terms that are understandable and that are that you're able to execute on. You know, we're talking a lot about the changes and rules that need to be applied today with these changes, and there is no limit to the amount of rules that you can create. TCN also has built-in data management services that eliminate entry errors and mundane tasks, business intelligence dashboards, call recording and call storage, smart IVR with payment capabilities, speech analysis, and that's just the beginning. So essentially, regardless of the industry, company size, location, or application, TCN can provide a robust call center solution for your collection agency. For more information, or if you'd like more information, just give us a call, or you can go to tcn.com for more information. And again, thanks, Mike, for the opportunity.
Excellent. Well, thank you, McKay, for sponsoring today's webinar. Really looking forward to our conversations today and throughout the series as we move forward with other webinars on this topic. A lot of questions have come in from the audience. Let me see if we can take some of those. Michael, when you read the limited content message, someone asked that they were under the impression you could not leave the consumer's name in the limited content message. However, in your example, you did. Can you provide some clarity on that?
Sure, and I may have read it too quickly, and you may have thought I was giving the consumer's name. The message, the example that the CFPB gave to us is, this is Robin Smith calling from ABC Incorporated. So Robin Smith is the collector, not the consumer. And then it says, please contact me or Jim Johnson at such and such a number. So at no time are you actually leaving the consumer's name.
Got it. Thank you.
So,
Sorry,
can I interject on that, Mike? So that's something that we want to talk about, right? Because the collector has to use their full name, and whether you do aliases and how you handle that with certain states. So I was just curious if a lot of people do aliases. Our company doesn't do them at all because we don't want to mess with it, or whether you're going to have a comfort level of collectors leaving their full name, or how people are going to handle that.
Anyone have any thoughts? Go ahead, Mike.
I think that goes into the whole risk continuum and the analysis that you do internally as an agency. So, there's things you're going to look at and say, okay, if I do utilize this message, it's going to be deemed as not a communication under FDCPA. So it's really replacing the Zortman message that many of the agencies, I think there was a percentage, I think Zortman use was actually higher than 40 usage in that, and what you had provided earlier, Mike. So I think, as agencies review this, they're really going to say, okay, there is still a risk with leaving information about a specific agent on a phone call. I mean, they would give the name if they're speaking to the right party, but you're not always sure that you have the right party. When you're leaving a voicemail message, do you provide that in that message or not, or require it? Some agents aren't going to be comfortable doing it. So do you just have a policy that if the the agent gets to choose, if they feel comfortable leaving their last name, or are you going to utilize aliases to conform to that requirement? So I think that's an area that each agency is going to have to make that determination on what level of risk they're willing to assume there, and what they're comfortable doing with their agents.
And just from a technical standpoint, I didn't see a requirement that the full name be left. The rule just says the name or names of one or more natural persons. I think the examples use both a first and a last name, but yeah, and it could very much vary state to state depending on if the state has any alias implications for licensing and the like.
Did that answer your question, Sarah?
Yeah, I was just throwing it to the panelists because we don't use them in the past, but now I'm trying to decide if I want to change it. So I'm trying to get some free legal advice here.
Happy to.
Well, and the question that I've been kind of rattling around with this whole process too is, I think what the CFPB is doing is providing a limited content message that we can use as debt collectors and have the presumption that is not a communication under FDCPA. I don't think that they've gone so far as saying, if you're using a Zortman message today, and that's been deemed by some courts to not qualify as a communication, that you should discontinue using that going forward and use this. So I don't know what other panelists feel about that, but I'm not sure that this is an absolute replacement for Zortman messaging, but it does provide guidance directly from authoritative figure that allows that's provided with the the authority to provide rules around the specific elements of the FDCPA. So I'm sure it's going to have a meaningful impact on court cases that would go further.
From a practical stamp, oh, go ahead, Mike.
I was just going to say, just to pick up on what Mike was saying, this limited content message falls into this attempt to communicate. So it's not a communication as far as counting and things like that. So there are a lot of positives with it. But as Mike said, they're not ruling out that you can use Zortman or other messages that you think pass muster. One thing that's interesting about, I think, the Zortman message is they did make meaningful disclosure of their identity, the caller's identity, and they did give the mini Miranda. So they actually complied with all aspects of the FDCPA in that messaging. They didn't say who it was for, and the boogeymen that we're all talking about in this whole situation is third-party disclosure. That's why we're having this conversation. And I would ask those 34% of the people who are using Zortman, how many lawsuits have you had to defend where you left that Zortman message and then someone sued you for a third-party disclosure? And I'll bet you it's a zero. Mike and all the lawyers on this call will tell you, we do not see those claims. They don't come in. So this boogeyman that we're all afraid of isn't there.
The only difference being a Zortman message counts as a communication.
Yeah, well, if you're doing more than 7 communications a week, you're doing something wrong anyway. That's a different soapbox I can get on if you want.
Another question that came in from the audience, which is a good one. Are we able to use the limited content message now? I know the rule hasn't even been published in the Federal Register yet, let alone wait the year before it goes into effect, but the rule has been released by the CFPB. If someone uses a limited content message now, is it something they could use as a defense if they get sued for using it?
Well, that's the can you do it? Yeah, you can do anything you want. Is it defensible? Probably not, because right now it's going to be deemed to be probably a communication. And you didn't do meaningful disclosure. You didn't give the mini Miranda.
I think it's more defensible than it was 3 months ago, because it's in a final rule, and you can talk about what level of deference could be given to the CFPB's analysis. But yeah, I generally agree with you, Michael.
It just goes back to what you were saying, Mike, about the risk spectrum.
Yeah, and I agree with both parties, Britt and Mike. I think we saw the Green versus True Accord case that talked about email, but in that case, they actually provided information about what the CFPB proposed rules looked like at the time when they actually worked through that analysis. And the court didn't use it as absolute deference, but they did identify it and talk about it in their order. So, the question is, can you or should you use it today? And I think Mike's right. You can do whatever you want, but technically the rule doesn't go into effect, and we're not required to follow it for a year from the date that it's actually provided in the Federal Registry or announced in the Federal Registry. And I don't believe that's happened yet. So, we still have more than 12 months to conform to it. It doesn't mean that you can't do it early. You can implement anything that you see that may be valuable to your business from the CFPB's proposed rules. If you want to put the call volume restrictions in place now, you can. It doesn't mean that you're going to have, the protection from that necessarily, because they're not effective yet, but you definitely can start going down that path if you so choose.
I want to clarify just one thing Michael said, where I believe that the limited content message actually does count toward the number of communications you can have in that 7 period. There's an example on page 623 that addresses that with respect to call frequencies. It's Roman at I. It says the example is, on Wednesday, April 1st, a debt collector first attempts to communicate with a consumer in connection with the collection of a credit card debt by placing a telephone call and leaving a limited content message. Between Thursday, April 2nd and Tuesday, April 7th, the debt collector places 6 more calls to the consumer about the debt, all of which go unanswered. As of Tuesday, April 7th, the debt collector has placed 7 telephone calls to the consumer in connection with the collection of a credit card debt within the period of 7 consecutive days. So they're presumed at that point to have complied with the 7 and 7 rule, and the limited content message does count against that.
Thank you, Britt.
Sure.
I misspoke.
So, and Britt, just from a clarification perspective, it doesn't create, because the outbound call creates an attempt. So it's
Correct.
not an added number. It's just that same, you're not going to add it twice just because you leave a voicemail message, but you are making that outbound attempt that you'd have to, tally in that 7-day amount.
Exactly.
It's basically if the phone rings as opposed to a fast busy type of thing, that's going to be an attempt. And it
Exactly.
counts. Okay.
I would be interested getting back to the participant who asked about ringless voicemail. There is no example about ringless voicemail, so now you kind of, well, does a ringless voicemail count then? Getting back to your point, Michael, about, well, phone rings, so I don't have an answer on that one.
I'm going to take this. I'm curious. I'm going to launch another poll asking if you're going to be, if you know yet whether you're going to be using the limited content message. Curious to see how many of you plan on using it, don't plan on using it, or still aren't sure. So we'll let that collect for a few minutes while everybody responds. Let's see. We've got a bunch of questions that are all on the topic of, what can we say with our company name? I'm going to get to those in a minute. Let me ask you this while I'm waiting for these answers to come in. Putting on your plaintiff's attorney's hats, because I know everybody has one. What areas of the limited content message do you see are likely to be grounds for filing a lawsuit? Is there anything that kind of jumps off the page or that you see might end up the subject or a claim in a lawsuit?
With respect to the limited content message, early implementation. I'm not saying they have a good case. I'm just saying that's the easiest one.
And I would just go ahead, Michael.
No, Britt, I didn't hear what you said.
Oh, early implementation, starting using a limited content message now before it's, the rules will be effective.
Mike?
And really, I think it's any variation that you have outside of those examples they provide. So, I think I go back to a lot of, companies that contact me and say, what do we use for a Zortman style message? And you try to keep that as closely related to the actual language that was used in the case. And I would suggest the same thing here is you want to stay as close to that prescripted language that they provided, or plaintiff's counsel are going to think that they have a payday, or they're going to test the theory of whatever you add to that statement. Is that still considered a limited content message or not? And I know a lot of agencies today want to utilize, their web portals. Everybody's focused on self-service. So do you add, the web portal as a way to contact you back? So, this is Robin Smith calling from ABC Inc. Please contact me at Jim Johnson at 1-800, whatever the number is, or visit our web portal at whatever. Is that going to still be considered a limited content message? And the push for self-service it means a lot to agencies, and it helps from a recovery and a profitability standpoint. So it's, but it has been tested and it's not included in that statement. So do you add it or do you not? Those are the things that I think we'll probably see the tests from plaintiff's counsel.
On the agency side, from a practical standpoint, it says may, and we were talking a little bit earlier about if collectors are comfortable with their name and maybe having different collectors using different messages. And I would say that'd be a biggest area I would be nervous about. I think you've got to train your collectors. It's one way or the other. If you leave it too much up to them getting to ad lib and do things and make a decision, I think you're going to fall afoul of consumer attorneys.
All of us have defended cases where the legislature came up with what the validation notice should say, and then creative agencies decide to reword it, and then they get sued for it. This is a safe harbor that the CFPB, once it goes into effect, has said, this is what you say, that's what you should say. Don't ad lib, as Sarah just said. They do give you some other things. You can give a salutation. I don't know what that means. Dear kind soul. This is Michael Cluth. I don't know what that would be. They give you can say the date and time of the message, right? Suggested dates and times for the consumer to reply to the message. And a statement, if the consumer replies, the consumer may speak to any of the company's representatives or associates. So you can pack some more in there if you want, if that makes sense to you.
I like that it says you could say hello, but it doesn't say you could say goodbye. Sharing the results from our poll. 34% of our watchers and listeners today plan on using the limited content message. Only 7% have said they are not going to use it, and 59% are here to get our guidance from our panel about whether or not it's a good idea. So we're changing, hopefully changing a lot of minds today. So thank you all for sharing that. We've got a few questions in about company names. So let's see if we can tackle some of those. Do you feel the words adjustment company would be acceptable if you're leaving a limited content message? Anyone want to weigh in on that?
I wouldn't recommend it.
Yeah. I actually think before even getting into specific words and what's going to count and what's not going to count, I actually think that this is one area that the CFPB is begging for an advisory opinion request on. Personally, I think that parts of this actually conflict with another part in the regulations about how the debt collector has to use, their true name. And so I actually, as great as we all think the limited content message might be, and I agree with Michael, it answers a lot of questions. I do think it's a very good thing for the industry. It's not perfect. And I think that this is perhaps the biggest area, the most problematic area. What name you're going to use.
Yeah, we're struggling this because we have Premier Credit. So credit's kind of, is that something? Or our other subsidiary is Performant Recovery. So is recovery, too much? It's really, we're struggling with it internally ourselves. I don't want to give anybody advice on it.
But if I could roll,
go ahead,
Mike, if I could roll back the hands of time, I would have enacted the FDCPA in 1977 to prohibit the use of a name of an agency to have collection or adjustment or anything. Premier, you get Premier Credit. I mean, it would have solved a whole heck of a lot of problems where you have a statute that prohibits disclosing you're in the debt collection business, and then agencies decide to name themselves, that they're in the debt collection business.
Correct me if I'm wrong, but have there not been lawsuits where the company, a plaintiff has claimed a company name has been misleading? So if you don't have credit or collection in your name and you're calling from ABC company, are you opening yourself up to potential lawsuits by not being clear enough about who you were in a limited content message? Or is that the safe harbor of the limited content message going to provide the cover that you need from those types of suits?
I think you're kind of perhaps conflating if you're using your name and hoping that also provides the mini Miranda. If you're given your legal name and you're given the mini Miranda, they're going to know who you are. And I don't think you're going to have any problem with that limited content message. This is, to me, the folks that have indicated are going to wait and see. I mean, this seems like a safe harbor. And somebody asked a question, is there a template script from the CFPB? What I read is coming directly from the CFPB. This is Robin Smith calling from ABC Incorporated. Please contact me or Jim Johnson at this phone number. That is the script that they have provided. Use it. It's a safe harbor. See if it works. Compare, your collections for the next 6 months using it to the 6 months before when you didn't. If it gives you some bounce, go for it.
A couple other people have asked about company names. A couple that have come in that are more sort of law firm names, like Smith, Jones and Associates. We had as one. Another one, Johnson, Riley, O'Brien. Can you leave a name that's obviously a law firm, or can you just eliminate the company name and use the actual caller's name in its place? But in your script, you have to leave the company name, right, Michael?
It's what what the rule says.
Right.
I don't know that a law firm name is problematic because it doesn't indicate that they're a debt collector. It could be implied, but there's a lot of other collection agencies out there that are not technically law firms, that they utilize maybe, two last names, and associates or whatever, or just one name and an associate or whatever the case may be. So there's a lot of variations out there. I don't know if we can solve for all of them. Each one's going to be unique, but I don't know that a law firm actually has any problem leaving the name of that agency or that company, or any company that has two names in it that could be considered, or people may confuse and think it may be a law firm because there's two names. There's tax accountants, tax professionals or accountants that use their last names on their PLLCs as well. So I don't know that that's problematic in any way under this theory.
An interesting question. Is there a constitutional challenge here with the Bureau saying you can't say your company name if it implies collection? No one willing to make that argument?
I think it's a stretch myself. I mean, I'm assuming they're talking about the First Amendment and what ACA did probably with the Attorney General probably sparked some of that discussion, which was a great argument. The way that they had constructed that prohibition or rule during COVID. But, I think this is probably a little bit different. Does it say that I think what they're trying to do here is not identify, the type of business the company's in and to not qualify it as a communication. It goes back to the element of, can an agency leave a different type of message? And the CFPB is not prohibiting you from using Zortman or some other type of message. They're just saying, if you want to safe harbor from, and identify that it's not a communication or FDCPA, this is how you leave it. So I don't know that the First Amendment or, a constitutional argument would work there. Maybe wrong. That's not my area of expertise either. So.
Other than potentially affecting the number of callbacks you get, and sort of in turn the amount of collections you're able to recover, are there any other downsides that any of you see to using the limited content message?
I think that's an arguable point. Is a consumer more likely to contact a company back if they identify themselves as a debt collector or not? I don't know what the statistics suggest on that, but based on the Zortman message where you actually identify that you're a debt collector versus this limited content message where you don't, and you can't even have anything in your name that suggests collections, what's the probability or their expected return based on this type of message? And it could be higher than what we've seen in Zortman because the people don't know that you're calling about a collection account unless they Google your name, which most people probably will do before they respond back. So it's an interesting discussion and probably something that needs to be tested on the agency side to understand what the outcomes look like.
Another interesting question. So let's say I get a call back from my limited message and the party asks who you are. Now, what do you say? Do you have to ask first if the caller is, you have to verify or verify the identity of the individual calling first before you can say you're from a collection agency?
Just hang up. Don't talk to them. That issue comes up in
Collections
Zortman,
101 from Michael Clutho.
Yeah. And that issue comes up in Zortman. It's the same thing happens. People do call back and say, I just got this message and what's this about? And I can't ever pronounce it. It's like Zwinkcraft or something. I don't know what the name of the case is, out in New York or East Coast. And the judge, because they sued and said, well, now you're disclosing it wasn't the consumer. They said, here's who we're trying to get a hold of. And they claimed that it all linked up with the mini Miranda being a debt disclosure to a third party, and the judge said, give me a break. So that was actually a positive case. And we haven't seen really much in the way of litigation where you go through and it's an inbound call. You treat it just like any other inbound call. Identify the person. You probably are seeing the inbound call number on your caller ID, pulling up the account. Just handle it like any other inbound call.
Or, exactly to Michael's point, even, how many times do you get somebody, if you don't leave messages now, you say, oh, I would just saw this number on my caller ID, I called it back, I would just treat this under that same procedure that you probably already have in place.
And Mike Frost, how many lawsuits do we see as a result of this? Zero.
Yeah, not a whole lot. We in my past experience, utilizing the Zortman message really just doesn't create a lot of liability. The big question that I have with this statute, and I don't know that I got this right, is does it apply to live attended messages? And if it doesn't, then I think we're in a position of it's a problematic situation, because on the one hand, you have this prescribed opportunity to be able to provide this non-communication voicemail message to a consumer. But if you have to do it in a pre-recorded message situation, then you potentially run afoul of the TCPA, because the TCPA doesn't really care about the ATDS argument. It specifically says, or a pre-recorded message or an artificial voice. So, if you end up leaving a voicemail message on a consumer cell phone in a pre-recorded setting, you're likely to see those types of suits, and we still see them today. Those are still coming through for people that are leaving pre-recorded messages. So it's another area to respond to Mike again is, these are the areas that you see the plaintiff's counsel probably latching onto in a pre-recorded setting is one that I think will probably increase some after these rules.
Hey, Mike, there's a real good question popped up there about whether or not the limited content message triggers the need to send a G notice And Britt, is this one where we now are in an attempt to collect and we're not a communication? So we really aren't triggering that obligation, are we?
That's, I mean, I think it's a tough call. I think it could be, you know, I could see I could name several plaintiffs' attorneys who might bring a lawsuit on that. But I mean, I think that if you started calling, your letter should be out the door. And so hopefully that's what, you know, you're doing. But you know, I think this is going to get, you know, this could be a murky area for the CFPB. We know that attempt to communicate is not defined by the act. So did they overreach by now creating this attempt to communicate definition? And that's going to implicate the G notice because you have to give that within 5 days of the initial communication. If it's not in the initial communication, which it couldn't be if it's a limited content message. So I think if you're leaving a limited content message, that G notice should be out the door.
You know, I think the argument's there that since you haven't disclosed any consumer information in that limited content message, and it's not a communication under FDCPA, that wouldn't trigger the validation of those requirements. So, you know, while we're probably going to see litigation on it, and it's not going to stop the claims coming through, it is a defensible position based on how the rules drafted.
I agree, and it's probably a strong defensible position.
You know, and one of the interesting things about the statute, and I fought this with Joanne Faulkner years ago. So let's assume you start up your agency and you're going to have this limited content message to be your first out the door type of thing to try and save money, not send notices. The person calls back, it is the consumer, and they pay within the 5 days of that communication. You're not under any obligation to ever send a G notice. You just wrap it up and be done with it.
You open the door to pre-recorded messages, Mike. So we've got a question. Instead of relying on our agent to remember what she can or cannot say, can the agent start a pre-recorded message to start once she identifies she has reached the voicemail of the consumer?
You're still going to have to defend the argument that's not a pre-recorded message and doesn't violate TCPA. So I don't know that works. You know, a live attended message, I think you can script them out. This is especially if you're going to use the required content. I think Michael touched a little bit on the optional content. That talks about the best time to contact, which I wouldn't use that. Just my personal opinion, because that opens up another argument. You know, if you say 6 p.m. Eastern time, did you call Hawaii, and now are you outside of the prescribed time periods that you recommend to the consumer? And I mean, there's just a plethora of crap that's going to come in through utilizing that type of a message. So if you look at the very simple, very minimal amount of information you need to leave to not be deemed a communication, I'd follow that as closely as you can. But if you leave it in a live setting, we're all billed in certain different ways too. So you think about your billing structure, and one of the biggest issues I had back with the Foti message was, on average, it took 52 seconds to leave that message, and it was lengthy. It provided the consumer information, all that kind of stuff. We never wanted to leave that live. We wanted to leave it pre-recorded because there was just too much information. So same point that the person made this question is, do you want to have a really long message that you have to curtail and have an agent leave that every single time? A small script like, this is Robin Smith calling from ABC Inc. Please contact me, or Jim Johnson at 1-800 blah, blah, blah. I'm pretty sure they can remember that fairly easily, and you can script it out, put it on their desk until they get it down. I would feel very comfortable having my agents leave that message. I felt very comfortable when I was at an agency and an agency shareholder to provide the training to agents to leave that message. And I don't think that was problematic at all. Never really saw problems even utilizing the call analytics and the call miner products and stuff like that to be able to mine and see that they're doing it properly. The vast majority of them did it very, very well and correctly.
Now, I would say I'd feel comfortable with the first parts that have to be in there, but when you get to the May, it gets a little bit trickier. So for example, a suggested date and time for a call back. Well, for a collector in the month and I haven't hit goal yet, that might be a different date and time than, the first of the month. So we got to be careful with that.
Agreed.
So you mentioned that, Zortman lawsuits about Zortman messages, there's none or not very many. The limited content message is a safe harbor, not a communication. The Zortman message is 52 seconds. The limited content message is a lot less. Does this at the end of the day boil down to an operational decision and not necessarily a compliance one that an agency has to make? Like which one, and like we were talking about before, which one gets the better recovery weights? That's the winner. Is that how you would recommend agencies sort of approach this decision?
That's how I'd run my business. That's how I'd run my business. I'd be running mini experiments and see what brings in the most, return calls and the most dollars, and that's what I'd go with. Mike, I just said one thing. Mike Frost, did you say the Zortman was 52 seconds or the FODI was 52 seconds?
The FODI, if I said
Sorry,
Zortman, I apologize. Yeah, FODI was 52 seconds. Zortman was like 5 seconds on average. And, the way agencies are billed, they're billed on 6-second increments. So when you think about your phone bill too, you can actually get billed just under one segment of that cost. So you're going to eliminate expense too. And it might sound crazy, but every dollar counts in this business because the margins have just, collapsed over the years. So when you think about it in totality, it's a cheaper process to be able to use that type of message than a long FODI message too.
I'd say for agencies to consider the type of debt too. One might work better for student loans, a little bit more customer service, where another one might work better being able to say the word debt collector and things like that. So you're going to want to take it line of business by line of business.
So maybe where this matters most is with that group of 40% of the people who are watching today who aren't leaving voicemails. Maybe this is the, what sort of pushes them to choose whether to use the limited content message or Zortman or FODI instead of the group that already are using limited content. Instead of the group that already are leaving voicemails.
I think Britt touched on it. There is the other option of that not leaving message, but pulsing out your phone number. You will get returns on that. And somebody needs to go through all these data and find out what the real answers are and run, because there are 4 different ways. You got FODI, you got Zortman, you're going to have this limited content message and no message. And agencies ought to be mining their data to find out what's working. And as Sarah, you might have mentioned, it was maybe student loans. One works better for different types, but somebody needs to do some deep dives in here.
Not only is it, to add into the equation a little bit, not only is it about what's getting you the better return, but also what's not getting you sued.
Right.
If you decide that, this month we're going to try the FODI message and you start getting, sued or a few threats to sue, you probably don't want to be using that message anymore. I think it will be interesting to see in the next, 8 to 12 months, how many people continue to use FODI and Zortman. I think that the CFPB has provided a safe harbor. For the most part, it's a pretty good message. And I think you would be taking a much bigger risk by continuing to use FODI is probably the riskiest in my opinion, excuse me. And then Zortman, but whether or not the message is still going to be the question.
I would agree with that. And I think that statement about, really understand what the ROI is, and that ROI would include that equation of, how much money you have to pay out based on those different types of messages. So, think of that in totality. The other part about this is how much additional information the CFPB provided for us, which on the texting and email and all those other areas. And I know we don't have time to get into that today, but when you think about voicemail messaging, a lot of people were using, the direct drop type where you weren't ringing a phone and stuff like that, kind of went away from that. What I've seen lately is a lot of people are utilizing the texting platform to do it. And text messages were not, are specifically excluded from this actual limited content message. So, if you're replacing your voicemail messaging with an attempt to text the consumer, you may be looking at, are you going to be using Zortman or are you going to be using FODI in that type of a message context in a text in a different platform? So you may test all of it when you're thinking about an ROI is what's going to drive the greatest return. And quite honestly, I don't know that voicemail messages actually will may even be needed to be used because you're probably going to see higher rates of return in some of these other, electronic processes.
It is interesting to note that I'm pretty sure the limited content message in the proposed rule you could use across multiple communication channels, whereas in the final rule it's only in voicemail. Does anybody have any theories as to why that is, or what the CFPB was thinking in making that change?
I think part of it came out with the texting process where, in the texting and email context, they really only said that, hey, here's a safe harbor for unintended third-party disclosures. They didn't put a finite rule out there about how agencies can text. They basically said, if you do text and you want to have a safe harbor, this is one way to be able to create a safe harbor only for unintended third-party disclosures. It doesn't go into any other detail. So I think it was very limited in context of what they tried to prescribe. And I think they probably went along the same routes here is while they were prescribing that limited structure around text and email, they wanted to keep that limited structure and didn't include it in the limited content message, which is actually, in my opinion, better for agencies to deal with it that way than what rules may have come to restrict those electronic communications further.
Sorry, someone asked for what page on the rule the messaging information was on. I was trying to get that while you were going through your answer, Mike. I mean, maybe that's, are we talking section 1006.6, communications in connection with debt collection? That starts on page 566. That's probably a good place to start.
Yeah, 565 is the limited content message.
There it goes, 565. Thank you.
And that only provides the detail around the rule. It doesn't provide the scripts that Michael went through earlier. I think that's later in the rule.
Yeah, that's in the official commentary, and that is those are beginning on page 598.
I did post the CFPB did give us an executive summary, and it's kind of a nice little guide. I posted that. Folks want to click on that on the chat. A link to it.
We talked a little bit about advisory opinion. Someone suggested seeking an advisory opinion about whether a collector's website or portal may be left would be helpful for the industry. Is that something you think that would be worth seeking an advisory opinion on?
I saw that one, and it was interesting to me. The limited content message talks about a phone number that you leave for a person to call back. And what if that phone number actually went to, a payment portal or to the agency's website? Some sort of, I don't know. Can the phone number
dump you? Can the phone number put you into the agency's IVR? Is that okay?
Yeah, well, that would be an interesting sort of a scenario.
I don't see why you couldn't. And quite honestly, I think the CFPB probably didn't intend to restrict in the limited content message just to phone calls. I'm assuming that they're looking at, opportunities, especially with as narrowly tailored as they had the restrictions around, text and email. I think it's a good question to present to the CFPB because it'll give us additional clarity on whether you can add that. But it is, to me, it seems analogous to the two. It's really about that communication and contact with the consumer, and based on the consumer preference. So if the consumer doesn't want to contact a representative directly, which we know a third of the workforce today and a third of the debtor portfolios are all millennials, and they don't want to speak to anybody, right? They want to go to a portal, or they want to go to even a voice bot before they want to speak to an actual human. So, I don't think the CFPB is trying to restrict this down to only what is available through telephone calls and not utilize the consumer preferences, because that was, pretty clear through the entire CFPB final rule that they are focused on consumer preferences and communication. So I don't think that was intentional to not allow that additional information, but I think it's worth getting clarity from them.
Yeah, I agree with that. I think the name of the game now, and I think the CFPB has made it clear, is communicating with the consumer in the manner in which they want to be communicated. And that means having the ability to drive them to those channels. And so if you're going to leave a limited content message and you want to include, your website, because that's going to drive them to their preferred channel, then, ideally you should be able to do it. But I think it's a good area, if, to ask for, either an advisory opinion or an informal opinion that you can ask for as well. Absolutely.
And being a devil's advocate in this, I think that, obviously I'm not the CFPB, I can't get inside all the brains there, but I think that this seems like, this is, Robin Smith calling, here's our number, call back to such. And then the questions that are coming up, okay, so they call back, what do you say? What do you do now? I do envision that they were thinking that this limited content message would be a live interaction, so that on the inbound, that person would be able to identify who's calling and then make the necessary disclosures.
And that's a good point, because, if you leave the payment portal link on that voicemail message, and they try to type that in and secure it, it's going to identify that they're a debt collector, because everybody has mini Miranda or whatever context that they need to have on that payment portal for FDCPA compliance, because you have in your collection letter, so it becomes part of the letter, right? So it's all in that same review. So maybe they intentionally left that out specifically so there wasn't a third-party disclosure, and that's why you have the safe harbor for it. So, it probably is worth getting clarity, but due to the fact that they actually just left the phone number and didn't expand that to include, that additional self-service methodology, it's probably an area that plaintiff's counsel would probably attack as well. So it's probably worth getting an opinion there.
Michael, your point is interesting, and how you kind of are wondering if the Bureau thinks people are actually going to respond to the limited content message, because maybe they did think that, which is maybe why they kind of hedged their bets a little bit on emails and texts in other areas. I mean, there were several parts in the analysis where they said, oh, we're not really sure emails being used with respect to one area that stuck out for me was the payment reminders for post-dated check notices under 1692F. And I'm like, really? Because I get questions about that all the time. So, I kind of felt like there was a disconnect there with them. So that was an interesting point you made.
I think it specifically says, a live person to call back. So I think they're more intending to use it that way. I don't think an advisory opinion would be bad, but I think there's plenty of other things in the proposed rules that we might want to throw resources at than the web portal here.
Yeah, I'd kind of leave this one alone as the way it is.
We've got 4 minutes left, and there are 4 of you. So I'm doing the math. Everybody gets 1 minute to kind of wrap up. Any last conclude? Any opinions? Any advice? Any perspective? Any other free legal advice that you want to share? And I'm going to stop now, because if we get to 3 minutes, then I'm not going to be able to do the math in my head. So Sarah, we're going to start with you.
Okay. So I think as you guys are trying to figure out what you're going to do, it truly isn't just a compliance decision. As we've talked about earlier, you do have to consult your operations department. Now I say consult, I don't say let them make the decision, right? Because if you ask them what they want to do, they're going to want to blast everybody and do everything. So you got to make sure you're putting something in place that's reasonable for them and workable, and that's going to make sure it doesn't affect your bottom line without running afoul of any of the compliance rules. I would say these are discussions you need to be having now. So when you're ready to pull the trigger and things go in place, you're ready to rock and roll. You need to be talking to your training department, your operations department, your IT department, and everything else to see how we can make this work for everybody.
Excellent. Thank you. Mike Front.
I think if people, there's choice out there, and what are you going to do? If you do decide to go down the path of this limited content message, I always try to stay as close to that prescribed language as you possibly can. That's going to give you the best opportunity to be able to use the safe harbor, and that's really what you're trying to go for here. So and what the CFPB is trying to provide, they're providing you a safe harbor. They're identifying that's not a communication under the FDCPA. Utilize it as close as you possibly can as an agency, but also look at other methodology that you can use. I mean, this industry has been hamstrung for many, many years, and there's not been a lot of people that have ventured out in the text and email platforms. But we know that we can do it today. There's case law supporting it, and there's really good defensible arguments on that. So while this doesn't actually provide you any detail on texting and email, it does exclude the safe harbor from that. So does that really limit you in those other categories? I would explore those, because I think you're going to get a better return on them.
Thank you very much. Michael Clutho.
I would echo what Mike said. Don't stray from what the CFPB has told us to say. If you're thinking about going to potentially use a limited content message, and I would suggest that you should, I think it's a vehicle to see if you're going to get some return on investment. And I think there will be callbacks as a result of it. I'd probably call it back if I got that message, if it was coming from a live person with a nice voice. So the issue for me is most agencies have business or debt collection in their name or some variation. I think you're going to use the next 12 months to get your DBA registered every place that you need to get it registered, get it licensed, let the carrier know, whatever way you need to cloak your DBA to make it legal, do it.
I think we've all got to call Michael Clutho and leave limited content messages and see how many of them he calls back.
I'd call you.
Yeah, first and foremost, Mike, thanks. You always put on good webinars, good information for the industry. Thanks to the panelists. It was a really good panel. It was a really good conversation. I think I'll just summarize a little bit of what everybody said, because everybody said really good things. If you want to operationalize the limited content message, make sure you're following what the information the Bureau is giving you. I would definitely be careful about implementing it too soon. And to that point, it could take a while to operationalize the limited content message for the reasons that Michael was saying, for the reasons that Sarah was saying. So, you know, it is probably one of the brighter spots of the rule, in my opinion, but that doesn't mean it's not perfect. So, you know, use it with care, and hopefully people will call you back. You know, who knows?
Well, Sarah, Britt, Michael, thank you so much for your time and your insights today. Really appreciate you helping everybody in the industry better wrap their collective arms and heads around the limited content message. Also want to thank TCN one last time for sponsoring today's webinar. Please go to www.tcn.com to learn more about the company. Thanks to everybody who participated and asked questions. Hope we got the answers you were looking for. Stay tuned. We've got webinars coming up tomorrow on employee bonding in a pandemic. And then we'll have more webinars in this series coming up after the holiday. So I hope everyone comes back for those. Thank you again to everybody. Panel, awesome job. Really appreciate it. Thank you.
Thank you, guys.
Thanks, Mike.
All right, everybody. Stay safe, stay well, and we'll talk to you soon. Take care.
You bet.